सलाम, आदाब, नमस्कार, सत श्री अकाल दोस्तों, आप सभी का स्वागत है सिटीजन जस्टिस फोरम के इस वीडियो चैनल पर। हमारा मिशन भारतीय नागरिकों को उनके अधिकारों के बारे में जागरूक करना है जो भारतीय संविधान ने उन्हें दिए हैं। अगर आप हमारे चैनल पर पहली बार आए हो तो कृपया सब्सक्राइब करें, बेल आइकन को क्लिक करें, सबको चुने ताकि हम जब भी नए वीडियो बनाते हैं या ऑनलाइन जाते हैं तो उसको आपकी सूचनाएं मिलती रहे। और हमें बहुत खुशी होगी अगर आप इस वीडियो को अपने दोस्तों और संपर्क के साथ में साझा करेंगे। हेलो, वेलकम। I am Advocate SULAIMAN BHIMANI. I welcome you all to the Citizen Justice Forum video channel. Our mission is to empower Indian citizens by sharing knowledge about the fundamental rights which is given to them by Constitution of India. Our mission is to empower Indian citizens. We will greatly appreciate that if you share this video with your friends and contacts. Today's topic is on building trust and account audits. So there are fights because of the various things, and we have received 6 questions regarding how the interest should be charged and when the member should be considered as a defaulter, how much the interest should be charged, whether it should be passed in the general body meeting, and various other nitty-gritties of the day-to-day affairs, and what is the prime or main objective of forming the cooperative housing society. So we have with us today, and we are very fortunate that we have a very experienced person who is a chartered accountant, and he is the authority on Cooperative Society Act, MCS Act, and bylaws of the Cooperative Housing Society, and he is also deeply involved in how to audit. So he is a very good auditor also in the Cooperative Society, and he is none other than Mr. Ameet Israni, chartered accountant, and we are really happy that he is here with us to share his knowledge and experience about the Cooperative Society, how it is functioning and how it should function. Yes.
Good evening, friends. Last Saturday we discussed for about an hour, and we had promised that we will come back with more details. And we had also requested कि भाई जिनको कुछ कमेंट्स हैं या कोई इंक्वायरी है मैं डायरेक्टली भेज दें तो उसको हम आज तो जितना क्लैरिफिकेशन दे सकेंगे वो देंगे। अच्छे क्वेरीज आई हैं और आज थोड़ा उसी पे फोकस करेंगे एज अ कंटिन्यूटी ऑफ द previous session. That's why we have called it part 2. We may have part 4 as and when available. अभी जो questions आए हैं, some have come on the financial side because audit, the role of auditor is our heading subject. Auditor has, as I had explained in my last session, not only financial but also socio-economic. Auditor को पूरा देखना पड़ता है कि सोसाइटी, उसमें लॉज भी आते हैं, रूल्स भी आते हैं। एक क्वेश्चन मेरे को आया है कि ऑडिटर रिपोर्ट इशू करता है और रजिस्ट्रार ऑर्डर इशू करता है, अगर उसमें कॉन्फ्लिक्ट है to handle it. Request the members who have got such issues to put your comments and their suggestions of how you think this should be handled, and towards the end I will give you what I think the law wants it to be done. दूसरे आए हैं, काफ़ी आए हैं इंटरेस्ट एलिमेंट पे। ये सोसाइटी के आउटस्टैंडिंग पे इंटरेस्ट 21% है, किसी का 18%, मैंडेटरी है, नॉट मैंडेटरी है, रेजोल्यूशन पास किया, इंटरेस्ट कैसा ट्रीट करना, कैसा कैलकुलेट करना, किस तारीख से कैलकुलेट करना, जब पेमेंट आता है तो उसको अप्रोप्रिएट कैसे करना, तो उसमें भी थोड़ा हम डिस्कस करेंगे। और ये सब करने से पहला very important for us to understand what is a cooperative society, practically as well as practically, and why we have a cooperative society. We may not have had a cooperative society. We could still buy a flat in a building and everybody could own their building और कोई cooperative society नहीं होगा, और फिर भी हम अपना खर्चा एक पूल में डाल के सोसाइटी बना के हम रन कर सकते थे, तो सोसाइटी बनाने का जरूरत क्यों पड़ा? व्हाई इज द कॉन्सेप्ट ऑफ कोऑपरेटिव एंड व्हाई डज द मोफा और अदर लॉज से दैट व्हेन यू बाय अ फ्लैट यू शुड आइदर हैव a society or an association? Fundamentally, we have to understand the reason. The reason आता है अगर आप cooperative society बनाते हैं, तो society में the first cause that is there is the object of forming society. और पहला object is to get conveyance. That means the whole purpose of forming the society is to get a conveyance. Nothing beyond it. तो जब भी कन्वेंस मिलता है जमीन का या बिल्डिंग का, अलग फ्लैट का कन्वेंस नहीं मिलता। तो इफ यू डोंट हैव अ बॉडी कॉर्पोरेट, you will not get a conveyance individually. You may get property taxes individually, but the conveyance is on the land plus the structure on the top. The structure, if the land is government, then you may have a long lease. और lease भी body corporate को मिलेगा, individually each owner को lease नहीं मिलता है government से on the land. So those are the basic things which we have to understand. वो समझ लिया तो फिर उसका next step है कि अभी हम एक body corporate बनाते हैं, खर्चा हम लोग को चलाना है. The whole purpose is to run the management. में तीन major clauses हैं.
Here we'll take a small break. There is some issue with the sound, so let's take a small break and then rectify the issue with the audio.
Hey everyone, Nausheen Ali Sardar here. I just wanted to take a moment and talk to you about something incredibly important, our rights as citizens. You know, knowledge is power, and understanding our legal rights is crucially important in today's world. That's where Citizens Justice Forum comes in. Citizens Justice Forum video channel is doing fantastic work empowering citizens by sharing valuable legal knowledge. They are dedicated to helping us understand the fundamental rights given to every citizen by the Constitution of India, from insightful discussions to breaking down complex legal jargon. Citizens Justice Forum is making legal information accessible to everyone. It's like having your own legal guide at your fingertips. So, if you want to empower yourself and stay informed and be aware of your rights, make sure to stay connected with Citizens Justice Forum. And don't miss out on their fantastic content. Subscribe to their channel now and let's build a community of informed and empowered citizens together. Now,
Thank you. I hope we are clear now. In case there is an audio issue, please do put in the chat box because there's some, due to weather, we are having some internet issues. Now, coming back to the purpose of the audit, the purpose of the formation of the society and the auditor's role. The society is formed so that it could be a body corporate of a group of people to run their activities jointly, the benefit of all. Once you have the society formed, then there are some rules and regulations which have to be followed. There are bylaws, which is the internal agreement between the members, have to be followed. Those will be decided by the members. We have got the act and the rules which are applicable between the parties, which is the society, the members, and the first thing that we have now got, which I would like to take, is the question regarding election. Just getting over the election fever. Election is a major point that came up in the questions. The question was, there are different societies under 250, below 50, below 200, or 200 and things like that. And there are election rules which distinguish the method with these elections have to be done. If it is a society which is a small society below 200, which comes in class E, election of the election, and larger societies have to go via the registered office. But there is something which is very, very important, thing which is part of the law, which is common to all societies. The power to appoint election officer has been given to small societies directly. but how to manage and who can call. So the rules and regulations are as per the Act. So that Act applies to everybody. This may change with the Act. Now, what does the Act say? Act says that 6 months before the due date, the general body under Section 75 have to announce the process in the general body. So general body meeting of September 23 would announce held 3/24. Between September 23 and September 24, those have to be announced in the general body as per the Form X, which is an item which should be there as a mandatory requirement. And 75 section में है कि अगर वो नहीं किया तो there's a penalty on the. Second thing is the election should be held prior to the completion. You have issues at times when you give a notice and elections are not held. That means you have a period point which is the expiry of the previous term, which is fixed for 5 years or less, cannot be more than 5 years, and there is no clause to extend it. No ad hoc committee, no provision for ad hoc committee, no provision for a make good committee or a holding committee. What happens in such situation is registrar has to appoint somebody, because whoever comes to take charge has to be officially appointed within the law. That is why it is called duly constituted managing committee. And if the managing committee is not duly constituted, it has no power. So the power evaporates as soon as your duly constituted gets over, and registrar has to enter. For that we have a section 73I. And 73I is very clear that if the term expires, then automatically the committee members cease to exist. It cease to be members, and registrar has to appoint an authorized officer who has to proceed as per section 77A. That is mandatory. So neither the committee, nor the general body, nor the registrar has the discretion to override a statute. There is no provision for overriding a statute. But we do have a situation which is in a practical mode where the outgoing committee, the secretary of the outgoing committee, whose term may have got over, appoints an election returning officer, his term gets over. The question that arises is, it is an appointment which is taking place by a person who is not eligible to make that order result in an order which is legal. Would that amount to the returning officer saying क्या फर्क पड़ता है, election छोटा society है, करने दो? What is the auditor supposed to do in such situation? The answer is very simple. Auditor has to follow the law. It is a duty of the auditor, when he finds a situation like this, to make a report to the registrar, to put that report in his audit report that these are the violations of the bylaw and the act. So when he does the audit, there is a form that he has to prepare, which is Form 1, as per the audit manual. And as per the form, there is a provision, all the bylaws whose violations have to be stated. So that is where it will appear in his report. Copy of the report will then be sent to the registrar, and registrar would then pass an order, which is what I stated earlier. Auditor issues a report, and the registrar may pass an order. Correct that situation, then carry on the function, because the society which is run by not duly constituted managing committee and gets their signatures in the bank account really opens up room for criminal liability. Operating an account without being duly elected or duly appointed as per the law. So those are issues which all managing committee members have to take care of. All the returning officers have to take. Returning officer gets a letter. The first thing they would ask is, are you eligible to appoint? Is your term over? Term is over, then he cannot or he cannot accept the appointment. Refer it to the registrar, who will then issue an order. Even though it is a small society, because the person who is appointing, वो खुद ही legal नहीं है. जो लीगल नहीं है वो आगे जाके नहीं कर सकता। ये हमने देखा है बैंक्स में भी, जब भी बैंक अकाउंट खोलते हैं में भी वो रिक्वायरमेंट है इलेक्शन रूल्स के हिसाब से कि ऑल इलेक्शंस टू द सोसाइटी एंड द कमिटी ऑफ द सोसाइटी एंड द कमिटी हैव टू बी अंडर द सुपरविजन ऑफ द स्टेट कोऑपरेटिव इलेक्शन अथॉरिटी। पर काफी सोसाइटी में हम देखते हैं कि अदल बदल करके चेयरमैन चेंज हो जाता है, सेक्रेटरी चेंज हो जाता है, सिग्नेचर्स चेंज हो जाते हैं, एक रेजोल्यूशन बना देते हैं और सिग्नेचर बैंक एक्सेप्ट कर लेता है। So there is again an issue that whether the bank should ask for document. Now let us look at a comparison between Cooperative Society and the Companies Act. In Companies Act, when somebody becomes a director, the ROC has to be notified and a Form 32 is issued. The same basis, an election report is issued by the election officer. So even if you have a change in the office bearers, election officer को बुलाना है, इलेक्शन होगा, रिपोर्ट बनाएगा, रजिस्ट्रार के ऑफिस में सबमिट करेगा, उसका एक्नॉलेजमेंट लेगा, एंड दैट इज द डॉक्यूमेंट व्हिच हैज टू बी कैरीड टू द बैंक। बट इन द ऑडिट इट इज फाउंड मेनी अ टाइम कि इवन द बैंक्स नॉट वेरी केयरफुल इन इंश्योरिंग दैट इक्विवेलेंट टू फॉर्म 32, वो कहते हैं मैनेजिंग कमेटी रेजोल्यूशन भेज दो, सेल्फ सर्टिफाई कर दो। Now, the risk that is there in such a situation is that then any three people prepare a resolution, sign it on a letterhead which can be done on a computer, go and open a bank account and start depositing the society money into that account, may never appear in the society's official account, which is run by a duly constituted managing committee. You may not come to know later on till the audits are over. Big fiasco, and particularly with societies which have got large number of members, you could lead into a very serious dilemma as to how to handle it. So it's very, very vital for all the banks to ensure that they have that certification given by the registrar in the form of the election report filed with them, duly certified, and then they know who are the office bearers, and then go on to take their KYCs, not before. The person who is appointed, then action should be taken by the registrar for filing a criminal charge against the person who has knowingly appointed. So that becomes more like a fraud, or you may call it document which is not legally issued. So those are issues which one has to take care of. An auditor has to ensure that it is part of the report. The Section 73I is a section which has been introduced quite some time back, and it is very, very clear, and everybody is requested to refer to the section. I'm not reading it out here. Now we have the second question that we were requested for going into the deep diving is maintenance. There are multiple interpretations of the bylaw on how maintenance is to be charged, how interest has to be calculated. We should understand that bylaws are written in simple English. It's a legal document, but it is not worded in a legal language. It is worded in a very simple layman's language. So everybody can understand, because it is an understanding between the members of the building. और जो चीज बिल्डिंग के मेंबर्स के साथ अंडरस्टैंडिंग है, वो एक किस्म से है हम लोग ये करेंगे, फिर ऐसा करेंगे, ये काम करने के लिए ये प्रोसीजर रखाएंगे, तो इसीलिए उसको पूरे लीगल लैंग्वेज में काउच नहीं करते हैं, सिंपल टू अंडरस्टैंड ये करना है और वो करना है। फिर लीगल में जाना है या समझना है तो फिर वो एक्ट में आएगा या रूल्स में आएगा, गवर्नमेंट का जीआर निकलता है उसमें आएगा। ये यहाँ पर इसको हम अभी 3 पार्ट में डिवाइड कर देंगे। एक तो है चार्जेस are अब इसके लिए बायलॉ 71 क्या बोलता है? मेंबर शैल बी रिक्वायर्ड टू पे सिंपल इंटरेस्ट 1% per annum, such lower rates as is fixed of the society. The dues to the society, दिस इज द फर्स्ट पार्ट। इसमें इंटरप्रिटेशन आता है, वही बोलते हैं कि भाई बायलॉ में लिखा है 21%, तो दैट इज मैंडेटरी, सोसाइटी कैन रिड्यूस इट बाय पासिंग अ जनरल बॉडी। दूसरा इंटरप्रिटेशन है कि 21 इज अ कैपिंग, उसके ऊपर नहीं जा सकते हैं, तो जो भी इंटरेस्ट लगाना है, नहीं भी लगाना है, उसको जनरल बॉडी को डिसाइड करना है। उस पर फिर भी इंटरप्रिटेशन आता है, क्योंकि वर्ड शैल यूज किया है, मेंबर शैल बी रिक्वायर्ड टू पे सिंपल इंटरेस्ट, दैट मीन्स पेमेंट ऑफ इंटरेस्ट इज कंपल्सरी, शैल बी। लेकिन आगे चल के बोलता है एट द रेट फिक्स, so if they decide to fix zero, lower could be zero, because it says at the rate fixed, so rate could be zero, rate could be 1, not be more than 21. This is one interpretation. पे काफी disputes होते हैं, and it will be interesting to know is the opinion of the viewers, क्या opinion है वो डालिए, and then towards the end we will again go on to read more into depth.
Yeah, we'll take a break here and then we'll go forward. Article 21 of the Indian Constitution, a very powerful article. How I made a difference in the life of 5,000 families who were living in a subhuman condition in Goregaon. Literally, that Goregaon was a gaon, but was that a gaon? There were no roads, no street lights, no stormwater drains, no sewer connection, and no, what I said, no basic amenities. फ्रेम में ले ले, मैं बात करता हूँ.
We are back. Sorry for the glitch. We are having some internet issues here and some sound issues. I hope we are clear now. So I will read the bylaw 71 again. A member shall be required to pay simple interest at 21% per annum or such lower rate as is fixed by the general body of the society on the dues to the society. इसमें हमने क्लैरिफाई कर दिया आपको कि जनरल बॉडी में रेजोल्यूशन डालना जरूरी है एज मे बी स्पेसिफाइड. तो शैल बी रिक्वायर्ड टू पे at rates as is fixed. So shall be required as is fixed has to be read together. So shall be required is compulsory, as is fixed. So एक बार fix हो गया तो it is compulsory. अगर zero हुआ तो it's compulsory to pay zero. So that is the simple reading. Second simple reading is from the date the amount was delayed till the payment remains unpaid. From the date it was delayed. From the date it is delayed is the day after the due date, not on the due date. Many a times they start calculating from the due date. वो on the due date से calculate नहीं करेंगे. It will be calculated from the date the amount was delayed till the payment remains unpaid, which means that the day the payment comes in, on that day the interest should stop. अभी इसका इंटरप्रिटेशन जो निकलता है कि द फंडामेंटल मनी टू बी कलेक्टेड इज द मेंटेनेंस मनी, नॉट द इंटरेस्ट. इंटरेस्ट इज द पेनल्टी. तो अगर हमको मेंटेनेंस कलेक्ट करना है तो मेंटेनेंस का दिया है कि इस तारीख से इस तारीख तक अगर नहीं आया पैसा तो इंटरेस्ट लगेगा, लेकिन अगर आ गया तो इंटरेस्ट बंद हो जाएगा. Which means that whatever money that comes is first to be treated as the payment of maintenance. Then the remaining surplus is to be treated as the payment towards the interest. Because if it had been the other way around, they would have said the payment should be made on the total amount. अब इसमें word dues use किया है, so dues would mean including the interest accumulated. वो अभी जो अपना 154 भी आया है उसमें भी ड्यूज को डिफाइन किया है और डिफॉल्टर को डिफाइन किया है. एंड फॉर द सेक ऑफ क्लैरिटी व्हिच आई वुड मेंशन, अंडर द अमेंडमेंट द प्रोसीजर टू कलेक्ट द मनी by collecting or going to register is also clearly mentioned. As soon as you become a defaulter and you don't pay up, you go to registrar and claim your certificate. Not that you keep on holding on the outstanding for years together and keep on collecting 21%. It is the duty of the society, the managing committee, कि आप जाके रजिस्ट्रार से रिकवरी सर्टिफिकेट लो और अपना मेंटेनेंस का पैसा कलेक्ट करो, क्योंकि आपको मेंटेनेंस का पैसा जो है विच इज द मनी स्पेंट वो आपको रिकवर करना है. इंटरेस्ट का इशू नहीं है. इंटरेस्ट इनकम इज नॉट पार्ट ऑफ द ऑब्जेक्ट. हमारे ऑब्जेक्ट में टू कलेक्ट इंटरेस्ट इज नॉट देयर. इन मेनी डिस्कशंस विद द रजिस्ट्रार्स ऑफिस आल्सो the impressions are multiple, and then the example is given of the banks who collect the interest first. Now bank ka business hai to give money. It is not the business of the society. Society's business is to manage and maintain the building and to appropriate the cost of that expenses among all the members. A question then comes up is, some member may just not pay the money because he's investing it somewhere else on a higher income than what interest is going to pay, and then the rest of the people have to contribute to the shortfall of that member. To curb that possibility, the amendment says immediately you become a defaulter, you go for recovery. So maximum that is there is the due date, which is 90 days. Thereafter 90 days, nahi aaya paisa, 180 days, go for recovery. In 6 months time you get your recovery. Then you are fine. But in some societies I find that the outstanding is going on for years. 8 years, 9 years, 10 years. Even some societies have not done recovery for more than X number of years. And there is a limitation clause. That means the whole money will be lost. Nothing will happen if the limitation is applied or the member goes through a practitioner who will tell him how to do, what to do, and then get the waiver of the limitation or the advantage of the limitation. Then the question will arise, has the auditor made the correct report? Has the auditor reflected the finances correctly in the books? Are the books reflecting true and fair view? We again go back to section 81, which says that auditor has to conduct examination and verification, which means that at every audit, the auditor has to issue a report. Then if the recovery application is not made, there should be an audit observation saying the society has neglected and failed to file application for collection. It should not read, because the option is not of society. Society's first duty is to collect the money, not to allow it to accumulate and incur a show of expenses के against income दिखाना है. So it is not an income narrating exercise, because the objects don't permit that kind of a business of lending money to people at 21%. So that is an angle which, in fact, we have had a discussion with Advocate BHIMANI, who had some contrary views. So I would request him to also put his points forward.
So object of the society is not making money, means out of charging interest. So 21% is the maximum which the society can charge. But I have a little contrary view. If a member is not paying, and he's defaulting, we are charging him 21% interest. That is per annum. But there are some utilities which we are using, like water, electricity, and property tax. If you don't pay on time, the municipality is charging, MCGM is charging 2% per month. So it comes to 24% per annum. So the society is losing 3% and not making money out of the interest. That is not the prime objective. But suppose if there is a society of 20 members, 5 members default, then what happens? The other 15 people have to bear the and share the burden of the 5 defaulters who are not paying. So for me, that 21% is not making money, but in case if you pay late to the corporation, they are charging you 24% per annum. So you are losing 3% money. So it is not, as per my view, that society is making any profit or making money, and they have to run the society. So everybody has to cooperate and pay the money. There may be some difficulties due to COVID, or now I've seen the metro lines when they are being constructed, the whole entry to the shop is closed. So how he is going to make money? So he is going to default in paying your society maintenance also. So, but that is a human aspect. But how long you can drag on? So after 3 years, then you have to go for Section 91 for the recovery, because the limitation period starts after 3 years. So there are pros and cons, and I leave it to the audience that what do you feel, that 21% is less or 21% is more, or we should raise it to 24%, so that even if the BMC charges 24%, society is not making loss.
The BMC figure is a very small percentage of the total maintenance.
No. If you see electricity, water charges
doesn't charge. They disconnect. So
they disconnect, but then you have to pay the penalty for that also.
Well, it's 20
It's a
rupees.
nominal.
Yeah, no.
But the water charges and the property tax.
So there is a ratio. There is a ratio we have to look at.
Yeah.
And a member who signs a bylaw saying we are going to pay, in order to solve this problem, the act was amended, and now as soon as you become a defaulter, you have to file your recovery. That has become necessary. So this issue of keeping it outstanding for 3 years and 5 years would actually come back to bite the managing committee for not collecting on time. You may have a situation where the person has sold the flat, has gone away. It leads to litigation, which again leads to legal expenses. So partly I would accept that, yes, the authorities who charge interest for their amount, for that an answer could be done that whatever is your ratio of the unpaid bill of the BMC, on that you recover at whatever price you need, and the rest can remain at whatever price. But that would lead again to complication of accounting. Being a simple cooperative society, things have to be done in a simple manner, and based on that, we have to look at each society to work out in their own way and ensure that goodwill is retained, the cooperative spirit is retained, which is the essential part of forming a society, and not get into a situation where the charges and the outstanding and the interest accumulate. I have a case which has come before me where the maintenance is 2 lakhs and the interest has accumulated to 90 lakhs because of wrong accounting, and auditors somehow, managing committee somehow have ignored that aspect. And that creates a huge amount, because in the balance sheet which I saw, the maintenance suppose is 100, the recovery from a member is 200. So it is more than the maintenance amount, which is not the purpose of cooperative society and ought to have gone prior, so that it would not allow it to reach that stage. We have to understand that the idea of cooperative is to help each other. As Advocate BHIMANI mentioned, you may have a situation where one member may not be able to pay because of circumstances, like it has happened in cases of minors, where the only earning member passes away, a widow is not working, children are minors. There you have to hold hands, because you are living in a cooperative spirit. So everybody hold hands and make sure that the family is carried over their period of the bereavement, and help them in whichever way they can. Or society can even come and say, okay, fine, we will pass a general rule that for 12 months we'll have a moratorium, so they can pass a general body resolution which says that for the next 12 months we will not charge any interest on anybody, because nobody else is defaulting. Nobody has an intention to default. Therefore, they may remove that clause for 12 months and then again have a general body and decide what they want to do. Because after all, between people internally, that they have to decide. It is not a punishment, it is a penalty. It is not meant to disturb the already created situation in a house where they may have financial issues and to aggravate the financial issues. So those are angles from which one has to look, not necessarily on a mercenary angle. Abhi to ho gaya, हमको वहाँ 20% भरना है. But don't forget that if one person is defaulting, 90% have paid, BMC has been paid off, the element of penalty would only be on the shorter figure, what is short, not be averagely going on to the whole figure of outstanding. But this is something that we all have to do it ourselves and make sure we don't do it. Agar koi hai who is doing it on purpose, then obviously he has to pay the penalty.
Yeah, then he has to pay the penalty.
Then he has to pay. Then you can't come. You have to come with clean hands.
Now, normally what happens, the committee members, they have their own business, or they are working somewhere, or they are managers in some bank, or see, so they are voluntarily giving their time. So you also have to cooperate, and you cannot treat them that they are the employees of the society because he has become the chairman or treasurer or the secretary. So you put a pressure that now. So that cooperative spirit has to be there with the MC. So there are maybe, exceptionals that the MC may be not cooperating. But normally, the people, they come out of their own will, they volunteer themselves, give their time, So now, suppose if they are giving every Sunday 2 to 3 hours in the society office, that time they could have spent with their family quality time, or they could have gone outing, but they are sacrificing their family time and giving time to the society. So
society is an expanded family.
It's an expanded family. It becomes an expanded family. So these are the things which you have to keep it in mind, that how the society should run with the cooperation of each and every member, that we are doing good for the society, something good is happening for the society. So everyone has to come together and make the society a better living place.
Correct. And then now we come back to the auditor's role. The auditor, when he comes, that's why I use the word socio-economic financial audit, because the auditor has to consider and put everything down in his report, whatever he's observing, and prepare a report. The next thing that has come here is a conflict between the orders issued by a registrar and the law, and the report issued by the, I won't use the word law, I withdraw that, and the report issued by the auditor. There are cases where certain orders are issued which can be interpreted either way. Then it is for the auditor to take a call case by case and then quote the law. If it is a financial issue involved, then he has to be very specific if society is incurring a loss due to that. If the situation is that the recovery certificate has not been obtained and the limitation period has taken over and the court strikes down the extra amount, only allows the recovery for the balance, it will be the duty of the auditor to put that remark, place responsibility on who is responsible for the losses caused to the society. So these are very, very important points which the auditor has to mention. And in section 81, apart from the overview of the debts which he is supposed to do, he also has to file a report on the working of the managing committee, which somehow doesn't seem to be a common parlance. But it's very, very important that if the committee works in a way where it doesn't recover in time, it should appear as a violation of the law in the report. So that is the role of the auditor, to educate the members, to guide them, and to ensure that everybody follows and they fall in line on whatever we have to do. You got some questions?
So we have not got any questions today. Yeah.
Maybe we have been going on and off.
Yeah. So we will conclude here and take up in part 3 in the cooperative society. There are many things which people should know about it, which they are not aware of it. What are their rights as a member? What are the rights as a committee member, and how they should perform? Our whole idea is, that committee and the members should come together for a common goal and make that society a better place to live in with your family and friends. So with this, we come to an end. Stay tuned to our channel for more updates on legal matters that affect you. If you find this video informative, then like, subscribe, and share with your contacts and friends for more engaging content on legal issues. See you again in the next video. Till then, take care, stay blessed, and be safe and remain healthy. Thank you all.
Hey everyone, Nausheen Ali Sardar here. I just wanted to take a moment and talk to you about something incredibly important: our rights as citizens. Knowledge is power, and understanding our legal rights is crucially important in today's world. That's where Citizens Justice Forum comes in. Citizens Justice Forum video channel is doing fantastic work empowering citizens by sharing valuable legal knowledge. They are dedicated to helping us understand the fundamental rights given to every citizen by the Constitution of India, from insightful discussions to breaking down complex legal jargon. Citizens Justice Forum is making legal information accessible to everyone. It's like having your own legal guide at your fingertips. So, if you want to empower yourself and stay informed and be aware of your rights, make sure to stay connected with Citizens Justice Forum. And don't miss out on their fantastic content. Subscribe to their channel now, and let's build a community of informed and